You're sharing your house with your ex-spouse and they slam the doors and leave at 2 a.m. Or maybe they say just enough to keep you scared, but not enough for the police to act. And so you ask yourself, can I make them leave before the divorce is done? Possibly, but only if you follow the law and have the right evidence. My name is Jeff Hughes. I'm the lead attorney at Sterling Lawyers, and we handle similar cases in Illinois every single week. So you don't have to guess on what comes next. In this video, I'll walk you through exactly when that's possible, what the law requires, and the one mistake that gets people denied even when they're right. Let's get started. How to ask the divorce court to make your spouse leave. Living together feels impossible. You're emotionally drained and your child's behavior is changing for the worse, and you just want peace. Some people think that they can just ask the judge to remove their spouse, but under Illinois law, it takes more than just frustration. Illinois law under this is found at 750 ILCS 5/501C2. That law allows the court to grant exclusive possession of the marital home during a divorce, but only if living together harms your physical or mental health or your child's. To qualify, you'll need three things. The first one is a verified petition filed under oath. You will also then need to have a hearing on the evidence to give to the judge as to why the other spouse should be removed from the marital residence. And then third, the court will weigh the hardship to both sides. I remember once we helped a client, Sarah, do this. Her husband wasn't violent, but he was acting out in passive-aggressive ways, and their son started wetting the bed again. So we filed a petition that had text messages, a counselor's note, and Sarah's own affidavit. And the judge granted her exclusive possession of the marital residence and required him to move out within 72 hours. So how do you get exclusive possession fast from a court order? Sometimes you can't wait weeks for a hearing, and you need the court to step in right now. That's when we turn to an order of protection. Under Illinois domestic violence law, a judge can grant exclusive possession even if both names are on the lease, and the judge can do that within 24 hours. Unlike a 501 motion, this law presumes the hardship favors you unless the spouse can prove otherwise, and that's hard to do. Once we helped a client, Maya, take this route. Her ex wasn't hitting her, but he was blocking doors, controlling her phone, and yelling at her in front of the children. So we filed a petition that included text messages, emails, a neighbor's statement, and her therapist's note. And the judge granted an emergency order, which gave our client Maya exclusive possession of the residence, stay away zones, and a no contact order with her ex-husband. So what evidence do judges actually need? Well, they won't grant possession based on emotion alone. They need clear, credible proof. So what does clear evidence look like? Well, it could look like threatening text messages, emails, voicemails, police or medical records, statements from a therapist, a teacher, or a neighbor. A detailed affidavit showing how your health or parenting is being negatively affected. One client came to us with a voicemail. It was of her ex. It was vicious, and he was threatening to ruin her. So we added call logs, a report of her child's behavior, and that was enough to win. So that brings up the question, what else can be included with exclusive possession of the marital residence? So getting the home is just part of it. Judges can also include stay away orders for work, daycare, or school, a police escort to collect belongings, a temporary parenting plan, and even firearm surrender if there's a risk of violence. We had a client once whose ex kept showing up to get things. A single clause in the order gave her complete control and police protection to enforce it. So, what route should you take? If you're facing emotional abuse or intimidation, get an order of protection. If the environment is damaging but not abusive, go to Law 501c2 and file a motion with the divorce court. If you have documentation in the form of text messages, emails, therapy notes, or witness accounts, all of that can work to strengthen your case. And the earlier you act, the better. Waiting tends to weaken cases. So if one parent gets the house, does that change who gets the kids? Judges look at parenting time differently when exclusive possession is in play, and getting it wrong can cost you both. So click this next video and I'll walk you through how temporary orders can impact custody, parenting time, and what you need to protect now before it's too late.